Sir, I just want to apprise one thing to Honorable Court. Lordships, I just want to apprise one thing. In 174, since it was a leading matter when it was heard for the first time, we moved the application, Lordships, for bringing on record the charge sheets that have been filed by the Enforcement Directorate. They also proceeded in the matter, and it has come into the public domain that various irregularities with respect to the RPSC members and their recruitment have come out, Your Lordships. If those charges may also be brought before this Honorable Court.
All right, we will see. Mr. Meel, we will see whether when you address, then we will see. Is it brief? All right. Along with submissions, the judgments are there.
My summarize that. The first issue which I proposed to raise is there was absolutely no opinion on record at any stage, at the stage of filing the petition, and at the stage when the final decision was also placed before the Honorable Court on taking a decision that examination initiated on the ground. Absolutely no material at any stage. That is the first ground which I proposed to raise. Second is the scheme of the examination is such. It has 3 stages, and the nuance is only with regard to the written examination. With regard to the physical aptitude test and the interview, there is absolutely no nuance. I'll explain it little later. Third submission would be that the narration of the facts and the material which have been placed relies upon the SOG report submitted along with the additional affidavit after filing the petition is also more or less, according to me, with all respect to the state, is a narration of the story. It is not an investigation. I will take your lordship to those in brief. SOG report does not say anything except talking about the past conduct of the parties. That would be my submission. Fourth submission would be that the petitioners are fence sitters. Number of them participated in the physical aptitude test as well as in the interview, and thereafter filed the petition. Waiting for, in case they would have been selected, they would have absolutely no grievance. The next submission would be that the final decision, earlier it was on opinion, whether it is the subcommittee of the Council of Ministers, or SOG, or the London Advocate General, these were all opinions which have, and an opinion could not have basis for giving a decision. The final decision remained unchanged, despite the fact that the applications were submitted by the state as well as by the selected candidates to dismiss the writ petition having become infractious on the ground that a final decision has been taken and is not under change the very single time. Dismisses those application on the ground that the release can be bound. I explain it that the release can be bound, but not if decision is yet to be taken. Another thing which I propose to raise is large number of candidates. This investigation is going on since 2021. Large number of candidates have not been found guilty, and therefore the principle of separating the grain and chaff, which is an age-old as old as civilization, that ought to have been applied. These are the broad issues on which I propose to release my submissions. The other submission which have been argued by my friend, Mr. Invigilator, I may touch them only while passing, otherwise not. More or less to remove it. Now, lordship should kindly then it request honorable court that I will have to allow you the submissions. Lordship should kindly appreciate that the entire foundation of the equity in the paper cutting and through FIRs. And even the paper cuttings which have been submitted, number of them were found to be erroneous reporting of the news, such as it was reported in the newspaper that the number of the candidates have been selected from one particular district, that is the district Jharkhand. And the newspaper said more than 100. When the statistical data were collected by the state government through the Department of Statistics and compared with the previous exam, final reports have been submitted, and therefore examination should be cancelled. It is not a writ wherein the petitioners are asking that the state should take a final decision. The writ's prayer is that examination should be cancelled. Only on the basis of FIRs registered. The FIRs are not registered against the candidates, but against the persons alleged to have acted. These FIRs run from page 101 to page 198. FIRs and FRs in all four. Registered at Pali, registered at Bikaner, Alwar, and brief of these FIRs we have submitted in our written submissions at page 5, where they were registered and when they were registered. Then I will bring to the notice of honorable court, page 199. The paper and that too is captured on the social media. The newspaper is publishing the news circulated on the social media.
Yes.
Submit that publication of the information or the views on social media, if they are started to be taken as a foundation for taking cognizance in the legal side, or there will be no end of it. Kindly see, sir, what does it say? RPSC के ओर से हाल ही 3 चरणों में आयोजित की गई SI भर्ती परीक्षा के बाद हमने का नाम नहीं ले रहा है। बुधवार रात को सोशल मीडिया पर परीक्षा केंद्र के अंदर का वीडियो और फोटो वायरल हो गए। एक अभ्यर्थी को OMR शीट में वायरल हुई है। OMR शीट पर अभ्यर्थी जयदेव का नाम लिखा है। 15 सितंबर की हिंदी सामान्य की है, वही वीडियो और फोटो वायरल होते अभ्यर्थी ने विरोध शुरू कर दिया। अभ्यर्थी ने RPSC की परीक्षा केंद्र पर परीक्षा व्यवस्था को सवाल के लिए खड़े किए। परीक्षा में 7.95 है करने के लिए। Then it also talks about some other examination में 4 गुना परीक्षार्थी कैसे होते हैं फर्जी वाला। Then on the next page again, this is with regard to the arrest of certain persons said to be gangs. Then the Lordship will kindly see page 202 on which I can refer later on also. एक ही तहसील से 100 थानेदारों की भर्ती was found to be absent. जालोर जिले से करीब 200 सब इंस्पेक्टर का हुआ चयन।
Is that which page?
So this is actually 202. The submission is that the examination for recruitment, appointment, these are the serious issues which affect the entire society. And on the basis of the news items which are published on social media, which ultimately are found to be wrong, the petitions cannot be filed and not have been filed. Now, what should we kindly see? Then right or wrong, the petition have been filed without any material. Then the candidates, they file an additional affidavit in the petition saying after the filing of the petition in 2024 and says, well, there is an assembly report now. And therefore, that is the matter which should be taken into consideration. Anyway, sir, they file an additional affidavit and submit some report. Then I have the result of that report also. Additional 416 of the record. But to my understanding, this so this additional affidavit came from 410. And what do they submit in their additional affidavit? May I just to my reason of page 410? And I'll briefly read para 3 and page 411. In para 2, they again submit some photocopies of the newspaper clips. And in para 3, they say that the state government, to prolong the matter while order dated 1/10/2024, has constituted the committee of 6 ministers of the state government to examine the matter related to the SI exam 2021. It is pertinent to mention here that there was no need to constitute the membership committee once the police headquarters in its report has been unequivocal terms recommended for the cancellation of the SI examination. Also, the learned advocate general has also opined that the SI recruitment 2021.
We could get that affidavit.
Sir, it is page 410 of the records submitted as extra affidavit
Of cancellation,
in production.
but we have a different thing.
Affidavit filed on 7/10/2024.
710.
2024.
For the single bench, we submitted the separate parts of compilation of 1, 2, and 3. If that is available, it is report number 1 of the 2000.
Please read it again. What are you, what A?
Sir, I am referring to para 3 of the selection.
Page he's asking. 411.
Page 411. Page 411.
411. ये हमारे पूर्ण देखिए दो बार है, चार the state government to prolong the matter.
Yes.
Yes.
There are 410. There are two affidavits.
That is the problem.
All right.
When SOG submitted its report, the final decision-making authority is the Chief Minister. The Chief Minister constitutes a subcommittee of the Council of Ministers. And also, this is an internal administrative management and also seek an opinion. But in all respect, I would submit. But this is the internal management of the administration. Opinions are sought, and as a matter of fact, these opinions cannot form part of the legal process. Rather, they are privileged to know. But if I express any opinion or I express an opinion that independent expresses an opinion, nonetheless they are opinion. Be that as it may, without entering into that aspect, the submission would be that the petitioners are again alleging that there is a necessity of now seeking opinion and appointing the council and asking the council of some committee of the council of ministers to examine the matter, cancel it. But what that report will, I am basically on that. Then they submit newspaper cutting and which are submitted along with it. ऐसा ही भर्ती रद्द करें या नहीं, इस बारे में सरकार ने पहले एजी से राय बाद में कमेटी का गठन किया. Please give this also a kindly turn to the report, which begins from page 419. In between, there is an order constituting the subcommittee. I don't want to read that. It has been called constituted and rightly constituted. Kindly turn to page 419, which is an forwarding letter dated 13th of August 2024 by Office of the Additional Director General, APS and SOG, which has been sent to the Director General of Police. So why I referred para 3 only for one reason. In para 3 of additional affidavit, they say that a report has been submitted to the government and therefore government should act upon it. Actually, this report was submitted by the Additional Director General of Police to the Director General of Police. And Director General of Police, and what does it say? May I read it? अंतर्गत निवेदन है कि उप निरीक्षक पुलिस प्लाटून कमांडर भर्ती परीक्षा 2021 में अनुचित साधनों के उपयोग से चयन से संबंधित अभियोग संख्या 10/2024 सपटे धारा 6 राजस्थान सार्वजनिक परीक्षा अधिनियम 1992 एंड 66 की सूचना प्रौद्योगिकी अधिनियम 2019 धारा एसपी राजस्थान जयपुर के अनुसंधान एवं इस भर्ती परीक्षाओं में अभिनेता से संबंधित परीक्षा से अभ्यर्थियों के अनुचित साधनों के उपयोग से चयनित होने के तथ्य प्रकट हुए हैं, जिनका विस्तृत विवरण संलग्न जांच प्रतिवेदन में है. अतः इस भर्ती परीक्षा को शुचिता, विश्वसनीयता एवं पारदर्शिता के उच्चतम मानकों को दृष्टिगत रखते हुए निरस्त करने की अनुशंसा की जाती है. So these recommendations are submitted to the Director General of Police. Director General of Police can send it to the government. So with all respect to this, again I would say this report require consideration by the Honorable. Sir, we have highlighted the broad points of the report and page 6 of my submissions. With reference to the ages and names. So, Lordship, you can see this report is divided into as many as 18 chapters. I'm sorry, 18 chapters. And these chapters have been there's an index at page 421. And this entire report talks more or less about the past involvement that you alleged without saying what happened in the previous cases. So I would like to read them. But can I request our report to have perusal of chapter 1 and page 425? In order to demonstrate what was the criteria which has become entire foundation. So in chapter 1, the only thing which has been discussed by the investigative agency is what is the scheme of examination, nothing beyond that. The राजस्थान पुलिस सबऑर्डिनेट पुलिस क्या कहते हैं, कितने आयोग and प्रक्रिया at page 425. When the advertisement was issued, when the examination was conducted, from page 425 till page 428. It talks about the examination scheme of the examination beyond that. And this cannot send to the investigation. So chapter 2 begins from page 429. And chapter 2 also discusses a particular gang. And what does it say, sir? When I with permission of honorable court reading. Para 1 at page 429. ब्लूटूथ डिवाइस मोबाइल की तरह का एक यंत्र है जिससे एक सिम लगती है, जिससे कान में एक छोटी मक्खी ईयरपीस लगती है, परीक्षा केंद्र के अंदर बैठे परीक्षार्थी को बाहर से अन्य व्यक्ति द्वारा जरिए मोबाइल फोन ऑन किया जाता है. एंड देन इट सेज वन तुलसीराम काले पुत्र आचाराम जाति जाट 57 साल निवासी गांव रामपुर, पुलिस थाना छापा तहसील सुजान जिला चूरू आज सो गौरव काला रोमप्रकाश सो और 91 में तुलसीराम काले का पुलिस उप निरीक्षक के पद पर चयन हुआ था. चयन के पश्चात पुलिस थाना डीटवाना से प्रोबेशन के समय में पुलिस थाना लाडू में हवाला रूप से संबंधित प्रकरण सो जिसमें अन्य अभियुक्तों के साथ तुलसीराम काले को गिरफ्तार कर चार्जशीट न्यायालय में पेश की गई, जिसके कारण तुलसीराम काले को पुलिस सेवा से 1993 में बर्खास्त कर दिया गया. तुलसीराम काले आईएएस 2007 में चयनित हुआ, परीक्षा परिणाम 2010 में आया. उप निरीक्षक भर्ती परीक्षा 2007 में तुलसीराम काले स्वयं विकास राणा के नाम से एवं दूसरे भतीजे गौरव कालर गौरव के साथ परीक्षा दी थी. दोनों के रूम में एक कमरे में थे. तुलसीराम काले और उसके भतीजे ने उत्तर पुस्तिका की अदला-बदली कर दी. तुलसीराम काले ने अपनी भतीजी की उत्तर पुस्तिका में प्रश्नों का उत्तर लिखकर उसे उत्तर पुस्तिका वापस दे दी. परिणाम स्वरूप गौरव काले का उप निरीक्षक पद पर चयन हो गया. आरपीएससी में शिकायत होने पर आरपीएससी द्वारा पुलिस थाना सिविल लाइंस अजमेर में प्रकरण संख्या 2/2010 दर्ज करवाया. दोनों को पुलिस द्वारा प्रकरण में गिरफ्तार किया गया. परिणाम स्वरूप तुलसीराम काले आरएस और गौरव काले उप निरीक्षक पद पर ज्वाइन करने से वंचित हो गए. वर्ष 2004 में तुलसीराम ने सबसे पहले जोधपुर में चाणक्य कोचिंग संस्थान शुरू किया. बाद में बीकानेर में चाणक्य कोचिंग संस्थान को शिफ्ट किया गया. तुलसीराम काले का भतीजा गौरव काले वर्ष 2011 से चाणक्य कोचिंग संस्थान विज्ञान गणित विषय पढ़ाता था. इस संस्थान के आम में तुलसीराम काले और गौरव काले ने कोचिंग संस्थान से संपर्क में आने वाले अभ्यर्थियों अन्य लोगों सरकारी नौकरी के आयोजित होने वाली परीक्षाओं में परीक्षा से कोई लीक करके ब्लूटूथ डिवाइस के माध्यम से निकल करवाकर सरकारी नौकरी में चयन कराया। आगे गैंग को परीक्षा शुरू होने से बहुत पहले पेपर की आवश्यकता नहीं पड़ती थी, क्योंकि सॉल्व एक पेपर परीक्षा के पूरे अभ्यर्थी को सेंटर से बाहर पढ़ाने की आवश्यकता नहीं होती थी। परीक्षा के लिए खर्च में ग्रुप से नकल करवाई जाती। सर, आई पॉज हियर फॉर अ मोमेंट. So what happened? These are allegations of against certain persons with regard to year 2001. They appeared, they were selected, they were not selected, and a case was registered. What happened in that case? Whether they were convicted? Absolutely not a whisper about this. The entire report is talking about 20 years ago. This examination was conducted in the year 2021, and we are talking about something alleged in 2001. It was incumbent upon the authorities, whosoever has prepared this report, to say that these are the persons who are convicted. It simply talks about their past. With regard to the present examination, sir, this next paragraph is also about 2014 examination. Then, sir, in the next paragraph, Rajanam, it talks about the background of Rajanam. So the last paragraph talks about the present examination. तुलसाराम काले और कोरो काले विद्यालय में चाणक्य कोचिंग संस्थान चलाते थे। राजस्थान पुलिस उप भर्ती परीक्षा 2021 के मुख्य रिजल्ट का आयोजन 13, 14 व 15 9 2021 को 2 पालियों में हुआ था। उप निरीक्षक भर्ती परीक्षा 2021 का एक परीक्षा केंद्र श्री राम सहाय आदर्श सेकेंडरी स्कूल रामपुरा बस्ती बीकानेर था। निरीक्षक भर्ती परीक्षा के 13 सितंबर से 15 सितंबर 2021 तक के सभी दिनों 6 प्रश्न पत्रों को लीक करने की योजना गौरव काले में राजाराम और राजू मैट्रिक के साथ मिलकर परीक्षा शुरू होने से पहले बनाई थी और राम सहाय आदर्श सेकेंडरी स्कूल बीकानेर स्कूल के संचालक मालिक दिनेश चौहान ने राजाराम और राजू मैट्रिक्स को अपनी स्कूल के परीक्षा शुरू होने से परीक्षा का पेपर लीक करने का सौदा प्रतिदिन 5 लाख रुपए तय किया। दिनांक 13/9/2021 को उप निरीक्षक परीक्षा में दिनेश सिंह चौहान ने राजाराम और राजू मैट्रिक्स की शिक्षक के रूप में ड्यूटी लगाई थी। परीक्षा शुरू होने से पहले सीनियर विभागों को खोलकर दिनेश सिंह चौहान ने राजाराम और राजू मैट्रिक्स को प्रथम पारी के हिंदी विषय का पेपर दिया। राजाराम और राजू मैट्रिक्स को पेपर की फोटो अपने मोबाइल से लेकर गौरव कालियर और तुलसाराम को अपने मोबाइल नंबर पर भेजी। पारी का पेपर होने से पहले सीनियर विभाग को खोलकर दिनेश सिंह ने राजाराम और राजू मैट्रिक्स की दूसरी पारी का पेपर निकाल कर दिया। राजाराम और मैट्रिक्स को परीक्षा को अपने मोबाइल से फोटो लेकर गौरव कालियर और तुलसाराम को मोबाइल नंबर भेजी। परीक्षा शुरू होने से पूर्व हिंदी के प्रश्न पत्र को सॉल्व करने के लिए गौरव कालियर ने चाणक्य कोचिंग संस्थान बीकानेर में हिंदी पढ़ाने वाले नरेश दास चाणक्य में पूर्व में सामान्य ज्ञान पढ़ाने वाले प्रवीण बिश्नोई जगदीश बिश्नोई ने के सॉल्वर के पेपर सॉल्व कराया। अभियोग संख्या 10/2024 सूचना प्रौद्योगिकी के अनुसंधान के दौरान एससीबी द्वारा तुलसाराम काले गौरव काले राजाराम राजू मैट्रिक्स नरेश चाणक्य को गिरफ्तार किया, जिन्होंने उपरोक्त तथ्य उजागर किए। एफआईआर की प्रति चुनाव पर सर इसका कोई समय that this report of a special operation which is specially constituted is talking about the allegations leveled in the FIR. No investigation. And these allegations are there. They have collected the money. FIR is registered. And there are statements recorded by the police. But I need not say that a statement recorded in the police, does it have any value? In order to establish that the entire scheme of the entire examination has been fulfilled, who are the beneficiaries? It doesn't say. It says these persons, they have a past, bad past with all. And this time they have done it, and therefore, why are they? Further, what do they say? पाली पुलिस की कार्रवाई at page 432, बीकानेर पुलिस की कार्रवाई at 433, then at page 434, make identification. So even after recording, what they say is they don't say anything. This is a probability, and that is what my submission would be. That this report with regard to this is also based on a probability. Can I order the Honorable Court to have revision of page 424?
Yes, yes.
There are begins from earlier to now. There are no. Only last 3 sentences. राजेश बेनीवाल के मोबाइल के व्हाट्सएप बिजनेस ग्रुप ऐप के एग्जाम मास्टर से दर्जनों लोग जुड़े हुए थे, तो उसकी संभावना से इनकार नहीं किया जा सकता कि जनाब 13/9/2021 को प्रथम पारी के हिंदी के पेपर का बड़े स्तर पर सर्कुलेशन होकर अन्य अभ्यर्थियों तक नहीं पहुंचा. So they are saying nothing with the anything which is fun. They say that there is probability that it might have been. There's no fun expression of opinion given by the SC.
Were the candidates allowed to take mobiles in the examination?
No, they are not permitted to. Therefore, in the report, in this chapter, what do they say? एक मक्खी की तरह लगा लेने वाला डिवाइस से मोबाइल बाहर लेता है, कान में लगा लेता है. Only for this purpose they have that. And for regarding the probability of paper, what does this report say is कि वो तो पहले से एक गैंग ने बीकानेर के अंदर किसी को सॉल्व करने को दे दिया था और वो कान से उनको सुना रहे थे. These are persons who are sitting in different classrooms and also appreciate one more. These are this is an objective type of intelligence. Not an objective type, more than 100 questions. They try to solve. But I can't say I intend the correctness of all these things. But is it a sufficient criteria? On the basis of which the entire examination can be cancelled. Then much order about the thing. SOD report. But all papers are with one uniform voice are talking about the SOD report. And there is absolutely nothing in the SOD. It simply talks about some probability. On the basis of which the entire fate of the number of candidates who have been selected is in effect. But once you talk about the mobiles, nowadays the strictness is such that they are not even permitted to hear certain type of approach. Anyway, sir, then I proceed.
Yes, yes.
Then, sir, kindly try to page 426. Para 154. अनुसंधान से स्पष्ट है कि दिनांक 13/9/2021 को प्रथम पारी के हिंदी पेपर और हादसा सेकेंडरी स्कूल पूरा बस्ती जिला बीकानेर से जीत किया जाकर सॉल्व किया गया तथा मोबाइल के विभिन्न व्हाट्सएप ग्रुप में सॉल्व न्यूज़पेपर को भेजा गया तथा इन सॉल्व न्यूज़पेपर बड़े स्तर पर सर्कुलेशन. So this will say, but they not say which are the mobile numbers on which it was circulated. Who are the persons who have been benefited? This report is totally silent about that. And therefore, sir, if I am permitted to say this report is more or less storytelling. 91 में आदमी ऐसा था, फिर इसका परीक्षा में चयनिंग हो गया था, फिर ये वहां से निकल गया, फिर वापस आ गया, इसने अपने बच्चे के साथ गैंग बनाई. स्टोरी नॉट एन इन्वेस्टिगेशन.
All right.
Then sir, it talks about the another gang, Jagdish Vishnu. This is Kadir. And it was well aware of these gangs. Though it is not the scope of this thing, he did not take any action against them. So then it talks about the Vishnu, some other thing. Alleged. With all humility that my commands are, I would say, Jagdish Vishnu का पेपर लीक करने संबंधित प्रकरणों की सूचना, then a chart is being given, which begins from year 2009 at page 438. 2009 and last the present examination. Sir, again, the cost of implication I would submit that what happened in these previous cases, since 2009, it was necessary for that information to incorporate in this report. And whether those examinations in which they had the candidates, whether those examinations were cancelled or not, nothing. Then, sir, at page 440, the allegation regarding the present examination. Conclusion of which is at page 442. And this conclusion also said 42 people were mentioned by. Since I have promised all report to take 45 weeks, therefore I am reading
All right.
all 442 page, which says 42 persons were found to be involved. उदयपुर में बेकरिया में प्राइवेट बस के साथ 42 लोगों को नकल करवाई, इसे बेकरिया कांड के नाम से जाना जाता है. I'm sorry, sir, this also passed on. Then, sir, it says, in order to justify that entire examination should be cancelled, this special group NS and the last para of this page 442 stage, इनकी गिरफ्तारी के पश्चात नकल कराने वाला बड़ा गिरोह सामने आ सकेगा. इस तरह गिरोह द्वारा आगे पेपर पढ़ाया जाना स्वाभाविक है. इस तरह नकल करवाने का एक अंतहीन सिलसिला है. इसकी तहत तक पहुंचा टेढ़ी की है. रमेश मीणा अजमेर में रेलवे में नौकरी करता है. इसके द्वारा काफी संख्या में अभ्यर्थियों को नकल करवाई गई है. रमेश मीणा अपनी नौकरी पर दाव लगाकर गिरफ्तार से बचने के लिए फरार है. अरुण शर्मा अरुण कुमार कहने पर को 100 पेपर पढ़ाया. अब इसी है रिपोर्ट सेल्स कि इस पर पहले पहुंचना तो बड़ी टेढ़ी की है. And completely silent about the present examination. With regard to present examination, regarding Jagdish Vishnu again, the report is at page 445. Till then, they are talking about the whatever little experience I have.
We say that they said 444 page. पेन सारण द्वारा SI भर्ती का सॉल्ट लीक पेपर सुरेश ढाका के 50 लाख रुपए में बेचा. सुरेश ढाका द्वारा अपने साइट हैंडलर्स के माध्यम से बड़े स्तर पर अभ्यर्थियों को नकल करवाई गई है. नो SI भर्ती का 44 सेकंड पैराग्राफ. भूपेंद्र सारण सुरेश ढाका
परीक्षा के बाद होने वाली
इसमें भी मुख्य आरोपी फरार है.
कार्य मीडिया बस कार्य इसकी अब तक इंसान दिमाग में कितने आवश्यकताओं के साथ उन्हें क्या करना है और इसका also on yes that some Suresh Dhaka who is accused in an NC case and in this kind of charge these persons are ultimately acquitted. And based on this examination is cancelled. That would be a great injustice. So at page 445 of course here they talk about the
That argument was not accepted by the Supreme Court in the case relating to West Bengal.
but therefore by formulating which I am not accept. But then also the owners report says there should be a foundational investigation. It should say conclusively that yes, this has been done. Now, what were the controls we were looking for in West Bengal case? Here it was found that the persons admitted in West Bengal, the West Bengal
Of course, the things which have been outlined in that judgment relating to that West Bengal case are much more difficult. But one thing which, after the learned advocate general argued yesterday, and we were going through. So, one is the systemic failure, which we, prima facie, subject to what you say, is with regard to this aspect regarding the members of the PSC who were having possession of the paper and having leaked that paper at that level.
so can I first explain that also?
Yes.
Actually, I can talk about the members of RPSC. Actually, two persons against whom the cabinet members, the other members, one Babulan Kata, another Ramuram Rai. As far as Ramuram Rai is concerned, allegation against him, he was never ever associated with the setting of the papers, and he was not position of it. It was Babulan Kata. So allegations and that dealt in this report as well as by the Ramesh. So allegations are only against one member, that is Ramuram Kata. Ramuram Rai के खिलाफ जो allegation है, that allegation is that he approached and opted for his son and daughter. He gave it to anybody else because he was not having and he was not in possession of the question papers. So that allegation is only against one member, that is Babulan Kata. I believe the learned advocate general has clarified it. And the learned single bench has also dealt with it. Ramuram Rai, so when they say RPSC members, no, only one member was there. And that too doesn't say. He will not just say, I will first touch that point. Instead of
We won't be disturbing your line of.
very well, sir. So my respectful submission is, here in this report, till then at page 448, again these gangs. But since I did not propose to read, I have already determined my different submissions for paras. But the tenor of the argument is that these reports are talking about such gangs, talking about their past, and much has been said about the past, not with regard to their role and impact in the present exam.
Yes.
What was the impact?
Yes.
What was the impact in the present exam? What was the impact in the present examination is more important level for the purpose of cancellation of the entire. And this report is silent on that. That's in chapter 6. at page 469. It gives a list of the candidates who have been arrested and against whom charge sheets have been submitted. And it's captured in that page 469. दिनांक 13/9/2021 को डमी अभ्यर्थन के माध्यम से चयनित निरीक्षक और परीक्षा के दौरान गिरफ्तार डमी अभ्यर्थी. And then it says, at page 471, in the bold, just about a chart, इसका सीधा तात्पर्य यह है कि किसी अज्ञात स्रोत से बैंक के पास पेपर पहुंचा, निचोड़िया हरेंद्र कुमार की गिरफ्तारी के पश्चात पेपर लीक करने वाले रेडर का खुलासा हो सकेगा. तो दे आर नॉट कंफर्म. The persons have been arrested and some persons are required to be arrested in order to justify this report. Chapter 6, 7, 8 also talks about the arrest warrant. And then chapter 10 talks about the persons against whom cases have been registered but are absconding. And eventually, till that time, only 53 candidates were arrested out of the. So till chapter 12, up to page 492, they talk about the persons who have been arrested.
Yes.
Nothing beyond that. Then this is information in report that these are persons who have been arrested.
Arrested and those who are absconding.
And so on. Thank you. Page 493, it again talks about the draft cases कौन से मुकदमों की सूची है. So first, in one chapter, they say FIRs, repetition of the FIRs in compilation, in the form of chart. And then it said, chapter 14, what are the judicial pronouncement? So the investigative agency, which is said to be an expert investigative agency or special agency, is also talking about the judicial precedents just to justify its recommendation. That should have been left for the other thing of the state. It talks about interprets in fellow. It talks about the state of Tamil Nadu and all other judgments. Then at page 497, it talks about the West Bengal judgment. It said that from the residence of minister, number of a large amount was also. But sir, they didn't say anything that these judicial pronouncements are applicable on this case. It simply refers, so it is a cut paste of the judgments and their paras, nothing beyond that.
Continue, please.
So my submission was, sir, they are according to judgment. Purposely they are so experts. You should have said that the judgments are applicable in the present case. My submission is the report is filing are pages, but these are all base pages. In chapters 15, sir, then they do not talk about this. Then they assume the jurisdiction of advising the state. And it says, इनको संख्या को समाप्त करने के लिए क्या क्या किया जाना चाहिए. So the investigation becomes suggestive also. At page 498. उपनिरीक्षक भर्ती परीक्षा 2021 की जांच में परीक्षा के आयोजन में उजागर व्यवस्था संबंधित खामियां. इसमें ये कई लोगों के नाम भी देते हैं. इस स्कूल में यह इस प्रकार का था, उस प्रकार इस प्रकार के इसको प्राइवेट स्कूल को नहीं किए जाना चाहिए इत्यादि इत्यादि. And finally at page 500 parasitic says कि RPSC को पहले एक दिन में परीक्षा आयोजन की रखी गई थी. उसके बाद अचानक आयोजन होने से पेपर लीक ऑप्शन बढ़ गए. विद्यार्थियों को बैठने की संभावना बढ़ गई है. So give some suggestions of it. Sir, can I also refer from the report to a terminal of paragraph 13?
Yeah.
FIR number so and so थाना लीकिया जिला उदयपुर दर्ज प्रकरण दूसरी श्रेणी अध्यापक भर्ती परीक्षा के मुख्य आरोपी सुरेश ढाका, सुरेश कुमार और आरती के सदस्य भावलाल कटारा के विरुद्ध जांच कार्रवाई की प्रक्रिया में रहते हुए आयुक्त भावलाल कटारा निरीक्षक परीक्षा के साक्षात्कार प्रक्रिया की जिम्मेदारी देने से प्रक्रिया की शुद्धता पर संदेह उत्पन्न हुआ है. RPSC द्वारा आयोजित श्रेणी के अध्यापक भर्ती परीक्षा की को एक वर्ष में पेपर सॉल्व करके संदिग्ध करे जाने की FIR नंबर 100 के आधार पर परीक्षा रद्द करती जबकि उपनिरीक्षक भर्ती परीक्षा में पेपर भी नकल करने कैंडिडेट से संबंधित 11 FIR नंबर बाद भी कोई कार्य So the SOP says the RPSC should have cancelled it because it cancelled in some other case wherein the persons were found in a bus that copying certain papers. They were not available in the distinguishing feature. Instead of in examination, those candidates were found in the bus. And therefore, RPSC itself cancelled the examination, and then it said RPSC के पूर्व सदस्य रामराव वाइटर के पुत्र मुक्ति के साथ चयन आम जन के मन में संदेह पैदा किया है. That is at page 503. अनुसंधान से उपलब्ध विचारेंगे. In para 4, it says number of applications that is created 33, complaints filed, submitted in SOP. So one of the reasons is that number of complaints are too many. So I pause here for a moment. Respectfully submit. If the disgruntled candidates file applications and complaints, will it be a candidate ground for cancelling the examination? This is what the SOP is doing, or has done at least in this report. If not doing, then in this report it has done so. Then, sir, in para 5 it says, वांछित फरार अभ्यर्थियों से भविष्य में खुलासे की संभावना. What should we also try to interesting explanation? Page 570. Para 13 of this chapter. क्या परीक्षा रद्द करने से मेरिट से चयनित उपमेरिट के साथ अन्याय होगा? Then it becomes suggestive also. कोई अन्याय नहीं होगा, इनको एक चांस और नहीं दिया जाएगा. So complete investigative agencies give a complete code how examination should be conducted, what should be done, what should not be done. This is not their business. Then in para 16 says, कि क्या भर्ती की परीक्षा को निरस्त करते हैं तो लिटिगेशन होगा. And thereafter in para 18, I'm sorry, chapter 18, it gives its suggestions. So by respect to submissions, I'm not reading this report again. But when this suggestion was made by the SOT without any further investigation, the committee of the subcommittee of the Council of Ministers and based on this material, a recommendation was made. Then I also request I will come to a revision of this final amendment. The Department of Home thereafter, when this was submitted to the Directorate of Police, Department of Home, which is the administrative department of the Department of Police, sends this
So far as this Babulal Khatara is concerned,
nonsense.
who was a member of the RPSC, he was also arrested in that Bekaria case, where there is a bus.
Yes, Your Lordship. She was already arrested in 2022, second grade examiner.
And he has been found to be the person who was having possession of the paper. Later
In the investigation in SI matter, he was found and taken on production warrant by the SOG.
Submission is only that one person. And
The question is that person, that one person, who was having the first possession of the paper and has been found to be involved in these gangs.
yes, I'm not denying. Submission is that is not only the levels, is what is one level.
Question is that if that paper has leaked and it has leaked and has gone into these hands of these people, can we say that the examination would be fair?
My submission would be
And we don't know to whom it has reached, to whom it has not reached.
that possibility.
And 68 people are absconding, 64 persons have been arrested.
Scholars list is not of the candidates alone,
True.
because as far as candidates are concerned, they are into categories one, they don't one, for various reasons. And most of the reasons is that they were selected for the service. They were undergoing the training. So most of them were arrested. The absconders are more understood than that they are the persons who are primarily responsible for duty cover.
No, for the who were some of them were the dummy, who are not to be.
But not the candidates. Safely saying, not the candidates. As far as candidates, that is the beneficiaries are concerned. The principle which will be applied will be how many persons have
The dummy will inform we appeared for whom.
That is the principle that they have to be separated. If there is a possibility of separation, then examination should be started. Nobody can justify that if something wrong has been done, those persons were there.
The question is only the ultimate aspect is that whether they can be separated.
That is the submission, sir. That the SOG itself is saying that only this much number of persons. If they say this number of the persons is limited.
SOG says that we don't know how many other people would be also.
Up to 2024, when the report is submitted, a pretty long time of 3 years. And even after submission of this report, number is not met. So if I recall one case of an IPS who was serving in the Kerala cadre, his certificate of caste was found to be wrong. And after a period of 30 years, services were terminated. So tomorrow, if any such thing is found again in particular first service, action can always be taken. The issue is whether the entire examination should be cancelled or not. Especially when number of persons against whom engagements are not there. Number of persons and coupled with the fact that disproportionate publishing in the media.
Yes.
But that is vitiating the mind also. And that is one of the reasons for the downfall of institutions as well. Not just my submission is that the material is taken place. And the next single bench heavily placed reliance upon this. So there is such type of report.
Yes.
Which ought to have, which definitely say this is possible, not possible. In 18 chapters, there is less investigation and more history. And more probabilities. So investigation has to be definite. When a challan is submitted, and the learned magistrate asks before taking cognizance that what is the material on the basis of which you want the prosecution, whether it is a sufficient material to take cognizance and start prosecution. Or this is the SOG report on. And it has to be a report dealing with the present examination instead of past. So I'm basically highlighting the shortcomings of the material based on record and matter. Whether this fall in the category in which the honorable period for cancelling the examination. This material is not of that category, does not fall in that category. Can I proceed further? As far as report is concerned, so the next submission which I propose to raise is that the scheme of examination is such that the entire recruitment is made under the Rajasthan Police Subordinate Service Rules 1989. That the entire nuances with regard to the written examination. There is absolutely no nuance with regard to the physical aptitude test. No nuance with regard to the written. Can you trust on the report we have pending on this use of 1989?
You can go ahead.
There are three stages of examination. First stage is an examination. I'm not reading, but written examination. In written examination, these are all objective type of tests. General duty and these are the subjects. I will invite Lordship's attention on it towards Rule 21.
Yeah.
And as far as the physical aptitude test is concerned, your Lordship will kindly appreciate Rule 21, Sub 6. Sub 6 consists of a chairman or member of the commission to be nominated by the chairman. An officer of the police department nominated by the commission in consultation with director level of IGP, not below the rank of IGP. An officer of the police department nominated by the commission in consultation with duty of IGP, not below the rank of deputy IGP. One psychologist nominated by the commission. So where physical aptitude test is taken, it is not board, which is by and large consists of the members of the police services in the rank of IGP, one comes from rank of IGP, one in the rank of DIG and one psychologist. And this would further visualizes that you must, candidate must necessarily secure 50% of marks for to be called in interview. So these are the candidates. All these three marks of information are not included in the overall manual. But to enter into the next stage, they must necessarily qualify and obtain certain percentage of marks. And they were found suitable there also. It is not that they are for those candidates who are not found suitable in the next stage of examination. And third is an interview. So that interview also the persons who are associated are so the same rule sticks. The aptitude test and interview of the candidates qualified physical aptitude test shall carry 50 marks for the post of sub-inspector and platoon commanders. And the composition of the interview board is also again same. A member of the RPSC, an inspector and a person in the rank of IGP, another member and person in the rank of DIG, and one psychologist. So interview board is also broad-based board. And therefore, sir, my submission is
All right.
that those candidates who have qualified in next two stages cannot be said that these are the candidates who have absolutely no mind. Pass in the written examination may be slightly more. Nonetheless, they qualified and they qualified the test in which the persons of the police department are also stated. And therefore, expertise and petitioners are silent about stage 2 and stage 3. Who allegation against the board. So I got your point. Though I'm not undo a job of Mr. Naika, Allegation against him is that at the stage of interviews of the district was right. But when two persons from the inspector, the police department are there, psychologists are there. Whether it can be said that they solely on the basis of some recommendations, some misdeed was done by but anyway, that is for Mr. Naika's case. So the submission therefore is, my second submission is scheme of the exam. First submission is, most of the candidates who filed the petition are cancelled. And for that purpose, in my written submissions, I would invite the attention of the court page 2. List of dates. So the advertisement was issued on 3rd of February 2021. Examinations were conducted to all these list of dates that I will given. Result was declared on page 3 last 11/4/2022. And all these newspaper cuttings which have been submitted are with regard to the written examination. They do not file repetition in 2022. Saying that, look, there is a wide spectrum, if not the viewers, about the malpractice adopted. Was it not incumbent upon them to improve the jurisdiction? The final result was also on 1st of June 2023. Next page 4. With pagination which has been submitted. And their appointment orders were issued in 4 stages. FIRs must register in 2021 on dates given. Yet the petition was submitted on 30th 2024. My respectful submission is the number of the candidates who are now complainants submitting a writ petition. They qualified the written examination, they qualified the physical test, they must have failed the interview, but when they fail, they raise their grievances. So they are very successful. The itself defeats their cause. This is what details have been given at in my submissions. Therefore, I will. So my next submission will be. The final decision was not changing that I have benefited my written submission at page 9. So the respective submission is. A decision may be good or bad. But when the decision had been taken, it was required to be taken. Especially when interventions were submitted under section 151. Then and that decision was taken on direction of this honorable court before the past that when we are reading this matter, each time the grievance raised was that when the report is there, the next state is not taking a decision. Then when the Single passes an order, when the state is directed to take a final decision. So the report of the assembly is not final decision. The recommendations of the subcommittee of the Council of Ministers of the final decision. The opinion of an expert is not a final decision. The final decision was taken by the head of the executive at the level of the chief minister, which was conveyed to the honorable court. And application was also submitted by candidates and by the state that what that decision or not. And the petition should be decided Either instructors, we can always ask that when we want to change it, and liberty should be given. But that order is required to be set aside. And order remains live and valid so long as it's not changing and decided. So there are two reasons when the petitions can be. No, a final decision is required to be changed. The jurisprudence is, as I understand, one, to bring a quietness to the controls. That well, a decision has been taken. Now the decision has become final. Therefore, whatever is pending should not be continued. That is quietness. Second principle is that when decision has been taken, the parties should be given the chance to attack the defend. So that decision is not changing. How so that the candidate selected and the state can defend that decision. At least state is having access to that decision as research required. Candidates do not. So my respectful submission is that decision which was not changing despite on record, the repetition ought to have been decided having become effective. So I have also submitted two judgments on this issue. Refer them along with the parent. I not be.
Anything you want to say relating to supporting the decision which the government has taken?
Which has been taken. Yes,
Because the learned single judge has not accepted it.
the decision of the state government is justified only on grounds one, that when SOD itself says that now instead of the second report of the SOD, that it has been justified. So in my submissions, I have referred it at page 10 of actual submissions. Para 7, 25/6/2025 is what it's saying. Page 1 at 7-9 of the written reports.
That para 8 which the advocate just read yesterday.
This line stays in the written report at page 1 at 7-9.
Yes.
In the form of an additional
Now,
agreement submitted by the state. 187. So this affidavit has been submitted and the relevant portion is at page 1880, para 4, and thereafter it says. Can I attention on the report where the instance SOG's report. Page 191. That the conclusive part of the report dated 25/6/2025 referred to here and. But I'm calling one moment state submitted in the form of affidavit this one. This complete report was not submitted on record on the ground that when this is a document which we are not filing, and if anybody can have access to it if they want to change it.
That is, I think, at page 1908. The final decision.
The record of the subcommittee.
मंत्रिमंडलीय समिति की अनुशंसा.
Committee of subcommittee council, committee of the council of ministers.
Fine.
SOD report permits here 1881.
That was given field cover, sir. SOG report second. Second SOG report was given in a sealed cover to the learned single judge.
Oh, that is not here.
You don't know, sir.
Just of it has been given in additional.
But the learned single judge notes that the entire report, apart from the conclusion, is in favor of the original petitioners.
Give me the second.
Thank you, my learned friend, but as far as the fact is that this conclusive part was on record. The issue is how to justify it and how to defend it and how to attack it. This is not undertaken. It was open for the petitioner to say that give this report to us. We want to change it, or we do not want to change it. So what does the report say? वर्तमान में जारी जांच पड़ताल में प्राप्त सुरागों के आधार पर प्रमुख गिरफ्तारियां
You are reading at what page?
conclusive part of the report submitted by the SOG for the second time.
And this report of 25th June 25 is not before us.
No, it is not. It was never.
All right.
Before the, and nobody has access to it. But in a judicial system, the court alone system, this they have their system and everything. But the parties have right to defend or not to defend. Clearly saying that it was seen and they have recorded that the event itself is a matter. And the issue is whether without changing the final decision, it survived or not. It did not survive. And on this part, with all respect to my learned friend, as well as to the Honorable Second Bench, I would say, sir, if this is the conclusive part of the report, can it be said that the entire report is in favor of the cancellation? No, it is not. It's said वर्तमान में जारी जांच पड़ताल में प्राप्त सुरागों के आधार पर प्रमुख गिरफ्तारी अब जो आरोपी फरार है गिरफ्तार कर विस्तृत पूछताछ की जाए तो उनके माध्यम से आगे कुछ और भी गिरफ्तार के समाज दोषियों को दोषियों से पृथक करने की कार्रवाई लगभग पूर्ण हो जाएगी. So assembly itself says most of the arrests have been made. Their number is not more than 60 or 63. A few more persons are abscondents, and therefore I explain that abscondents are not the candidates selected. The number of candidates at this stage, I also got to the next part of the book is 70 of my the exact number of the persons absconding, arrested has been mentioned. Based on the above assisted about 740 candidates of past, not only the sub-inspector recruitment examination for the about 7 other recruitment exams. Approximately 747 inspectors have been selected based on their capability from a hard one. The capability of those candidates cannot be counted. Out of the remaining 19, 64 have been arrested and 9 are absconded. And therefore, as soon as we gave a report, this is my submission. That number of persons have already been arrested and abscondents are only 9 as far as candidates are concerned. The grade and chaff has been separated. And that is what SOD itself says. दोषियों को निर्दोषों से पृथक करने की कार्रवाई लगभग पूर्ण हो जाएगी. मेरी बुद्धि के अनुसार तो इनको संभव है किया जाना. It's a matter of time on, but it's every possibility हो जाए. depends on the instances because the state says in para 10. But I was on the issue that the Council of Municipal
One question, Mr. Mathur.
Times.
You say that all right, grain has been separated from fat. These are tainted candidates, these are untainted candidates. As on today. Tomorrow, these tainted candidates, they challenge their action, your action of treating them as tainted candidates. After say 4 years or 5 years, because there are all possibilities. One way or the other, some of them may, then they would also claim, if we allow. Whether we go on probability or whether we go on strict proof. When we say, when we want an examination where there is definitely a leakage, whether we have to save that examination.
The law as has been made up is in such type of issues. It is not the strict. The criminal jurisprudence cannot be done.
Yes.
It is not the preponderance of the verdict that not the principle which is applied.
Is not preponderance of probability.
It is a firm probability. It has to be a firm probability. There is no other. And sir, tomorrow if these persons want to be called tainted, in what circumstance they can claim their
The way you have just now read that report saying that it is a story. No, when you say that it is a story, and the way you have put it can also be put by those.
Right to do that. But the persons who have been.
But the responsibility of the court and responsibility of the, especially of the court, is when things are brought before us, and it is brought to us that certain aspects have been there before the investigating agencies, before the court. View was taken earlier, second view was taken, two different views are there.
The shoulders of the.
Obviously, that is what we are just sharing with you.
That is what one says. I mean, therefore,
It's a very thin line.
the sign of the judicial, I'm wrong if I say this, that the entire judicial system sign is to have a balance. Balance is our science. And therefore, if it is found that only a few number of persons have been identified so far, and possibility of identifying other persons in future is also not so great. In that event, balance will be in favor of those persons who have toiled the soil of the bank and have remained successful in the examination. Some of them kept their services. So, if they can be separated, they should be separated. And that is,
All right.
that would be.
I think on that you would conclude.
I have already submitted.
Yes.
I mean, I will give you one now, benefited by the discourse of the senior faculty.
Yes, we would like. Mr. Badia is also here from. Yes. Yeah, of course, it's always that the.
Let's see them that I know. I have years of another submission to my internal articles.
But we have. Yeah. No. Why not? Why should you are asking for dinner? Why should you go away? And the weather in Jaipur is much better.
Otherwise, we would always be fighting. But in-laws are there.
Not necessary. You should have the first right.
Broker will always be of the professions.
Yes, Mr. Kamlakar. Yes, Kamlakar, please.
See that. Given the wide scope of nation impact as well as fiction of law, there might be a slight overlapping. But the first aspect that I would like to bring up, always condition, that what would be a stage at which the ultimate decision of cancellation is to be taken. Could it be the stage at which the decision is filed with whatever material it has?
Yeah.
Or could it be at stage, an interim stage in the process of the determination of the decision? Where on the basis of additional affidavits filed, the SIT report is submitted. Or would we be at the stage where a final determination, though yet to be made, is more likely to be arrived at on the basis of the material collected during the pendency of the writ petition and when the writ petition is being decided. These are not cases where we say that the right flows from the filing of the writ petition. These are matters where the decision is to be taken on the basis of the available material. And therefore, I would submit that though a right may crystallize at the filing of the writ petition, but that right is of the petitioners. But the decision ultimately is whether to cancel the entire examination or not to cancel the entire examination, to save the examination, to bifurcate and segregate the tainted from the untainted people, and to see the wider aspects of the conduct of the examination. And that is to be considered. Then in my humble submission, the relevant point of time is the ultimate decision making, which has not been left, it was originally left by the learning individual to the state government by the interim order of February 2025, on which the final SIT report was till later SIT report was submitted before the line was produced. And then ultimately the learning decided. I would go even to the extent further that now that that entire decision is being examined, whether the decision has rightly been taken by the learning individual, because as far as the recommendation was concerned, the recommendation was that it would be premature to cancel the examination at this stage, because now not only that it is possible to segregate the tainted from the untainted, but what the SIT said is that he will be able to complete the exercise of separating the tainted from the untainted. Meaning thereby that the exercise was already underway right from the very beginning. And though it still continues, but only a very, very minimal exercise is there. But what it says is that हमारी exercise पूर्ण हो जाएगी with a few adjustments. Not that the exercise will be undertaken now, but the exercise will be completed, will attain completion with the arrest of a few more. Now, in that respect, your Lordship may first see as to what led the state government and all the SIP to submit its report. The first order that was passed to constitute the SIP would be with me. Let me kindly see. Second order, sir. This
The order of the court.
Constitution of the SIP at page 1667. 167, 20th of March 1924, SIT had already been constituted. But what was asked by the state government from or expected from the SIT? The first reminder notice given to the additional director, General of Police,
167.
1667,
That's an order of 20th March 24.
20th March 24. उपरोक्त अंतर्गत विभागीय संसूचक पत्र दिनांक 15/3/24 की ओर आपका ध्यान आकर्षित करने निवेदन है कि प्रकरण में जिम्मेदार कार्मिकों अधिकारियों के आपराधिक मामले में दोषियों के विरुद्ध उचित कानूनी कार्रवाई कर भर्ती निरस्त करने के संबंध में आवश्यक कार्रवाई करवाकर इस विभाग को अविलंब भिजवाया जाने हेतु लिखा गया था, जो आज दिनांक पर अपेक्षित है। अतः प्रकरण के संबंध में नियमानुसार आवश्यक कार्रवाई कर इस विभाग को 3 दिवस में भिजवाई जाने की व्यवस्था करावे, ताकि वस्तु स्थिति से माननीय मुख्यमंत्री जी महोदय कार्यालय पर तदनुसार करता है। They were given the task, the SIT was given the task कि इसको कैंसिल कैसे करना है। One can understand the state government holding an inquiry. The judgments are already there. The state government was also aware of the judgment as to how and in what manner cancellation should be done, in what cases cancellation should be done, in what cases cancellation should not be done, and the examination should be saved. Like it's not a single day affair without, but that's a very in routine that one can cancel an examination of such a large magnitude. So therefore, if one considers, then the state government would have been aware of the order passed by the Honorable Supreme Court in what circumstances examinations can be cancelled and what circumstances the examinations are not to be cancelled. But if they give the task to the SIT to submit a report in 3 days and how the examination can be cancelled, and with that objective the SIT gives its report, then what sanctity could be attached to that SIT? Not saying that the investigations were already on, FIRs had already been registered. There is no denying about that. That certain aspects of the examination were in question, including the leakage of papers, including dummy candidates, including the role of certain officers of the RPS, members of the RPS. But nevertheless, if the SIT is given the task of giving a report to the state government, कि हमको पता है जब 3 दिन के अंदर आप सबमिट करो कि कैसे इस एग्जामिनेशन को कैंसिल किया। It shows that it was with the, at that point of time it was with a predetermined mind. And if that is to be now, Lord's kindly please to see at that point of time the investigation was on in relation to all the FIR. Nothing was in concrete. Nothing was there. Only probably three charge sheets that we filed against certain persons. Because the SOG FIR itself is in March 2024. So at that point of time, if you give the task to the SIT, then it obviously shows that the SIT and coming from the state government, the SIT could, in my humble submission, have given no other report. Their entire endeavor was to somehow or the other give a report for cancellation of the system. And that is why, as my learned friend Madhu was submitted, that the entire SIT report is only a narration of the FIR and the entire, not the action taken or an investigation made, but as to how it had taken such decisions that been taken earlier. Therefore, my humble submission is that at that point of time, when the first report of the SIT was submitted before the 13th of August 2024, that report could not be taken to be conclusive of the enormity of the maybe the mass, what they did as a mass scale cheating or leakage of paper, or the enormity of the irregularities in the exam. Now, for that purpose, necessarily, when the investigation was going on, and the learned single judge thereafter required the state government to take a final decision, and then that decision is produced before the honorable. The learned single judge does not consider that decision at all in his ultimate decision to cancel or not to cancel the examination, but relies heavily on the FIR and the report of the SIT 13th of August. And when I take a lot to the order passed by the London single judge, I am conscious of the fact that the lordship may have read a number of times here. And I'm also conscious of the fact that your lordship had passed an order earlier. That since your lordships are considering the entire matter afresh, so therefore we may not go into the order passed by the London single judge. But I would like to submit this to that necessarily this being a special meeting or against the order of the London single judge, your lordships would have to say if the content of our contention were to be accepted, your lordships would have to comment upon the order passed by the London single judge and find the errors therein. If your lordships were to uphold that judgment, the lordship still have to say that yes, that the reasonings given by the London single judge would be proper and leave no interference. In either way, the lordship will have to see the reasoning adopted by the London and then come to a conclusion on the basis of the available material at this stage, whether the decision given by the learned single judge, because what he says is the lordship contrary to what the state government has recommended, that it would be premature at this stage to cancel the exam. The learned single judge says no, you cancel the exam. So that's why the lordship go on to the reasoning given by the learned single judge. My endeavor would be to highlight certain aspects of the order passed by the learned single judge as to whether the reasoning given is proper or not. That would be one of the. Now, let me kindly see that as far as the first report is concerned, it has been dealt with by the Advocate General as well as Mr. Mathur. So I would not go into details of that. But then you'll often find that one aspect that is required to be considered by the Honorable.
Yes.
That in all the judgments that have been referred before the lordships, including the West Bengal case in West Bhattacharya, including Rishika Yadav, and all other uncertain cases, in all cases, the endeavor has been to see whether to see the magnitude of the irregularities and then to see whether the tainted and untainted can be segregated. And if after segregation of the tainted and untainted, it is revealed that the tainted people or candidates are far less in number or percentage of the selected total selected candidates. Then in the normal courts, the courts would not take a decision to cancel the candidate. Now, if that being the case, you'll have to find that apart from the criminal prosecution which have been investigated and investigated, apart from those criminal cases where a prima facie opinion may have been obviously worked, that would still be subject to the criminal prosecution in the court. But prima facie to take an overall view of the entire situation. A prima facie conclusion can be drawn as to whether they did or not. It does not mean that they were. What is, apart from these criminal prosecutions, what investigation, what could be the other ways of finding out and segregating the tainted and untainted? One was which was adopted and which was given a Dubai in the language synthesis and also not considered that ignored, was that the SOG conducted a surprise test of all the selected candidates. And the paper which had earlier been, which was there in the main examination, same papers were given to those candidates, and merit list obviously was not prepared, but they found out as to which was the candidate who could be said to have maybe copy or maybe have taken the advantage of unfair means. They found out, and on the basis of that,
Where does it come?
yes, in our reply to the writ petition, we specifically mentioned that. Lord, we kindly see the reply to the writ petition.
Has it come somewhere in the SOG report?
Lord, it has come in the order of the Honorable Court. Lord,
SOG.
Honorable Court.
He is only to assist.
Lord, in the reply, the Lord specific stand was taken. It comes. Lord, kindly see at page 1389, my lord. Reply to the writ petition filed by the respondent verse 50 to 59. And the same is there in the next reply also. Reply by 50 to 59.
Last paragraph.
On the page 1389. Last paragraph. That the investigating agency, that is SOG in the present SI recruitment 2021 had already conducted a surprise test of all the selected candidates who are under ongoing training in their probation period. They submitted that SOG after examining the result outcome of the surprise test further reasoned out 49 selected candidates from centers. Therefore, remaining selected candidates in centers including answering point of convert and now this was brought before the London Supreme Judge. And Lord, kindly see the order sheet of 15th of July 2025. 15th of July 2025 of the London Supreme Judge.
Order sheet. 15 July.
This could have been and was rightly adopted as one of the modes. No, I'm not saying the only mode. One of the modes to find out the tainted people. Person who has copied or person who has only used unfair means would never be able to repeat it again on a surprise basis. And it has led to the arrest of certain persons who were found that they could not successfully complete this examination. It says in compliance with directions passed in erstwhile order, Mr. Leakage Singh, ADG, ATS and SOG has marked his presence before this is in camera. This order was in camera. Proceedings were taken in camera. Before administered on 1924, an ad hoc analysis was performed during the investigation to formulate the inferences regarding majority candidate. Nevertheless, this analysis cannot be deemed tantamount to a surprise test, inasmuch as no marks were allocated to the candidate in respect thereof. On that basis, it has been not done.
Treated it as ad hoc analysis.
Yes. Now, this very person was the head of the SIT at that point of time. He comes and admits that yes, the surprise test has been held. But he says that this cannot be considered. Why is he not bringing the correct fact for the audit report? What was the outcome of this test? What manner this test was conducted? And if the same paper that is given to the successful candidates who are undergoing training, then what was the purpose? The purpose obviously was to see whether these candidates had or there was a possibility that they may have adopted unfair means. If that was one of the methods adopted by the SI, then why it was not taken to its logical conclusion? So therefore, at that point of time, what was in the mind of the SIT is more important. And that is why I submitted that if they had been given the task of cancelling the examination or giving a report for cancellation of the examination, then that itself your artificially indicated that the subsequent actions of the SIT at that point of time was all geared up to see that the exam is cancelled in some way. So therefore, whether such a report could be made the basis of the ultimate decision of the honorable court to cancel the examination. And it is not been for further arrest on the basis of these exams, this surprise test. One could still understand that all right. It was certainly an administrative exercise, maybe internal exercise, but it was certainly one of the very crucial. It was very crucial in the sense that it was a surprise test altogether. Nobody knew that they had to be given an examination. And all the selected candidates were asked to do that, to take that exam.
All right.
Now, you look kindly please to see. I would like to take a lot of to the order part of the London single judge. Look, the entire order reflects or the majority of the order is on the basis of the methodology adopted by certain persons for using unfair means. That is the FIR that has been registered in Bikaner, Pali, Jaipur, and one in Assam. Now, those FIRs were certainly in relation to the leakage of papers also. But you also kindly please the leakage of patients, especially let us examine one FIR in Jaipur, where they say that this one person, he had entered the office earlier. He was hiding in the office just before the examination papers were to be distributed. He took a photocopy of that paper, and thereafter that photocopy was sent to the persons who were engaged in answering those questions.
That matrix.
Yeah. And then again, by methods of Bluetooth or something, to be transmitted to those candidates who were taking the exam. By its very nature, that would be only for a handful of persons. It would not be an advanced thing. It may have taken place in various centers, these three centers. But how many people would be benefited from that? Obviously, it would not be for mass circulation, because as the FIRs go, that their entire operation was conducted to take money from these candidates, to supply the answers. If that was so, then it would necessarily have been supplied only to such persons who had wanted with their money, not to the general candidate. It would never have gone to them. If I was to take benefit of it, or I was to indulge in cheating, would I do it for all concerned? Why would I do it? Because then I know that the entire paper would be cancelled. So I give it only to those persons who pay me money. Why would I pay? Why would I disclose that paper or answer to everybody in the hall? And then also kindly consider that there are various centers. 24 persons are in one room. As the RPSC is before the epidemic. So how could it necessarily, I draw myself that how could such an exercise be undertaken en masse? It necessarily has to be only for a selective group who are party to. But the entire list of the order for the judge is only on the basis of these FIR, that these FIRs have been registered, that paper has been leaked to them. They had people to answer, or maybe answer all the things, and then they were transmitted by electronic mode to the student. But in the normal course, there is no allegation that in every center, in every room, the invigilators were on board. Up till now, that has not surfaced in the.
So that any invigilator was involved.
Yes. So therefore, if it was, then one can understand that it could have been distributed everywhere. Otherwise, the logic should be that because these invigilators, what this was COVID time, and the persons were being screened under the instructions of RPSC, which has been highlighted in their additional affidavit, which I'll show to your lordships. The RPSC has given specific instructions that there should not be at the entry gates, you should see that the distance is maintained between the candidates. They should be screened. They should be also disinfected. Proper sanitization should be done. All this exercise was being undertaken. And if the invigilators were not involved, then they would have easily caught persons with those telephones if all of them were involved. Because Bluetooth could not have been done without a telephone. So unless these people had mobile phones with them, all of them, it would not have been possible. Obviously, one can understand a lot, and it happens everywhere. In any examination, it can happen. People who are there to do unfair means. few and far between, and they escape the watchful eyes of the invigilator, but yet do it. But merely because 1 or 2% were making 1 or 2% or 5% do it, that does not mean that it is being done en masse.
Yes.
Then you are kindly also appreciate that as far as the leakage is concerned, leakage of paper, it is from the center. The lawyer posed a question, a query to Mr. Mathur, that Mr. Babulal Khatara, he had those papers with him. And those papers were given over to Ramuram Raika for benefiting his son and daughter. Yes, their education is there. But there is no allegation that the papers were leaked at the RPSC level. There is no allegation in any of the FIR.
But this Katara has been shown to have he has leaked it to others.
Yes.
Not only to this to Raika, but to other members of
There
this,
are
those
three.
gang where he is himself involved.
Other three
Yes,
brokers
in
also.
that case, no, relating to us.
Lordship, other three brokers also for a sum of 50 lakhs. Purushottam Dadij is there.
Let us for a moment assume that.
Yes.
What I am saying is that to how many people, because you are
There, that point we have taken.
Yeah.
We have noted.
how many people could be benefited by that? Maybe there may have been a leakage at that level also. It has to be proved, but let us assume that
Leakage is on consideration.
points
Leakage is on consideration.
contribute. Yes, I'm not obviously defending him, so I will not say anything about him. If he is to be booked, he should be booked, and we will see.
What you are saying is that if it leakage is on consideration, then it has also further gone on consideration. On consideration, it has further gone. To the concerned candidate.
The FIR say that these gangs which were involved, they sent their dummy people there in those centers, and from there they got the paper, and that was it. By way of the answers being given in two ways. That is the allegation in most of the FIR, apart from dummy candidates.
To those who paid money.
It could not have been.
It would not, they would not leak it to those who do not pay the consideration.
And payment is not to see when such a large magnitude examination is being held at such a large magnitude. It is impossible for these gangs also.
But a part of this interview board, no.
Khatara was, yeah, yes, sir. He has taken the interview.
The interview board.
Yes, sir.
Yes. There is no allegation as far as that aspect is concerned.
Sir, है इसमें भी allegations कि ऐसे कपड़े पहन के आना, I will give you the interview. There are allegations, the charges will be without.
All right.
I was told that even the VK thing who was editing the SIT, he was also part of the interview. He himself has given that report, but in that report there is nothing as far as the interview aspect is concerned. There may have been an allegation somewhere or the other, but no allegation that maybe proof or even evidence that Babulal Khatara had given marks to certain selected candidates.
The interview part, it is silent.
Raika is there. Raika is there. Ramuram, Raika's son and daughter. allegation in regard to Ram Naika's son and daughter is there. Then I asked of my
All right, you continue.
that letter, sorry, that Babulal Katara. So again, I am saying, I'm not defending him in any manner, but on the general premise, I am submitting that if Babulal Katara wanted to benefit some person, would he not restrict it? The same logic that it could for consideration, would it not be only for those selected? They have been arrested. Ramuram Raika's son and daughter have been arrested. So anybody who has been benefited from that, they have been arrested. Their collections have been cancelled. But can it be assumed that such a person who wants to benefit X, Y, or Z on a limited basis would then disclose the paper to everybody for nothing? So necessarily, a lot such an exercise would only be undertaken by a person who himself is seeking some benefit out of it. The benefit to favor somebody. To favor somebody, Ramuram Raika's son and daughter, that established. Okay, fine. But that by itself, would it mean that the entire process is vitiated? So I was referring to a lot of the affidavit of the RPSC matter. So this RPSC affidavit is allowed to find at 1509. There was a lot of discussion by the learned people just for cancelling the examination is also on
Yes.
three aspects which have been covered by this also learned. The learned signal just first says that the examination was scheduled for a single day and to benefit all these persons for unfair means it was shifted forward. The scheme was changed to 3 days. One. The second, he said that 2 shifts were undertaken, and that made things easier for these people to use unfair means and indicate the papers. The third aspect, he says is that 10 minutes extra were given for entry of the candidates into the examination hall. He realizing that that time was COVID time, and as I showed, I will show to you a lot from here as to how many precautions were to be undertaken before allowing a person entry into the examination hall. Let me see the affidavit first. Para previous applicant at page 1510. Read this one.
This is
That in persons of the advertisement, RPSC issued a press note dated 22/6/2021 for the schedule of the examination that was kind pencil press note dated 26/21 and hereby marked as annexure 882. That subsequently a decision, and it's not the level of the RPSC, that subsequently a discussion was taken place with the PS Home, DGP Home Department through video conferencing. Thereafter, decision was taken to conduct the examination in 3 phases. That subsequently, internal note sheet was drawn to conduct the exam at district headquarters in 3 phases from 13 September 21 to 15 September 21. Subsequently, it has been confined only up to 11 district headquarters after discussion and communication with the Home Department and district administration. Therefore, the kind parental relevant part of the notice is given. that subsequently by the press note dated 28/7/21, fresh schedule was notified to conduct the exam from 13th September to 15th September. In pursuance of the press note, written exam was conducted in 3 phases on 13th September 21, 14th September 2000, 15th September 11:50 at quarters Anwer, Alwar, Bharatpur, Bhilwara, Bikaner, Jaipur, Jodhpur, Kota, Pali, Rajasthan and Udaipur. FIRs are there in only 4 districts of Bikaner, Pali, Alwar and Jaipur for kind purpose. Subsequently, RPSC issued the result of the examination in the ratio of 1:20. Then physical efficiency test. Now you'll also see the decision making process which was adopted. Page 1523. Page 1523 number, right? Note sheet number 39. उप परीक्षा में लगभग 8 लाख अभ्यर्थी पंजीकृत हुए हैं। समस्त जिलों से मैं उपखंड प्राप्त क्षमता अनुसार परीक्षा एक चरण में जिला मुख्यालय व उपखंड स्तर पर आयोजित करवाई जाना संभव प्रतीत नहीं होता है। तथापि टिप्पणी विचारार्थ एवं आदेशात प्रस्तुत है। So they consider whether an examination of such a large scale could be conducted in one sitting and one session and one day. This is discussed a lot at page note sheet 42, discussed with HCM. As per his discussion with PS Hora and DGP, this is to be taken up them to assess possibility of conducting the exam in single phase. Meeting will probably be fixed within next week. Then the meeting is fixed. Para 42 N के क्रम में दिनांक 20/7/2021 को CS होम DGP होम डिपार्टमेंट के साथ वीडियो कॉन्फ्रेंसिंग हुई। वीडियो कॉन्फ्रेंसिंग उपरांत 3840 नोट के संबंधित निर्णय प्रकरण पुनः प्रस्तुत है। उपरोक्त प्रकरण में 45 उपरोक्त प्रकरण में माननीय अध्यक्ष महोदय के निर्देशानुसार 3 चरणों में परीक्षा आयोजित की जानी है। प्राप्त निर्देशों के क्रम में तिथि निर्धारण के संबंध में प्रस्ताव भी प्रस्तुत करें। So this decision was taken consciously a lot with the discussion with the home department to see whether such an examination should be conducted within one day as originally scheduled or 3 days. The learned single judge says that this was done solely to benefit the use of unfair means and leakage of paper. How could that inference or assumption be made by the learned single judge without on page to understand? Then Malad, note sheet at 46 Malad at page 1525 Malad. आदेश पैरा 45 एन की पालना में उप निरीक्षक प्लाटून कमांडर गृह विभाग पुलिस प्रतियोगिता परीक्षा 2021 का आयोजन 3 चरणों में किया जाना है। उस परीक्षा आयोजन हेतु 7/9/21 से 9/9/21, 13/9/21 से 15/9/21 और 25/10/21 से 29 तक 3 स्लॉट उपलब्ध हैं। उस परीक्षा तिथि निर्धारण के संबंध में कितने विचार आते हैं? And this was accepted. Looking to at note sheet 52, कितने जने कहाँ तक एकोमोडेट हो सकते हैं, कितने कितने जिला हेडक्वार्टर में या सेंटर्स के अंदर तो जैसे कि अजमेर में 35,000 हो सकते हैं, भरतपुर में 20,000, इस तरह से सारी की सारी डिटेल्स दी है। Arrive at a decision at 50. This is at note 52 वाला, at 55 वाला पैरा विकलांग अभ्यर्थियों के अतिरिक्त अन्य सभी अभ्यर्थियों को का परीक्षा केंद्र स्वयं के संभाग को छोड़कर अन्य संभाग में संपूर्ण रैंडमाइजेशन के साथ आवंटित किया जाना उचित। So what except for the physically disabled persons, they say that for all others, at randomized centers should be allotted to them, not being their home center. So that if all these persons, but in general and mass unfair means got to be adopted, they would have also said, not laid down this condition. They would have said, Allah किसी को भी कहीं पे भी दे दीजिए, होम हो या नहीं हो क्या फर्क पड़ता है? But they say, no, home centers will not be given to them, randomized, you give them a lot of other centers. So necessarily, these persons, except for a few who may have been known to these gangs, would not even be accessible to these persons, to these gangsters. Where was the question of being involved with these people who are general candidates? Or candidates in general. Then the ultimate I think. Right, page 1528, my lord. That is press notice issued. पुलिस प्रतिवेदन का आयोजन अपनी चरणों में 13/9 से 15/9 तक 2 सत्रों में किया जाना, 10 से 12 और 3 से 5. And accordingly, the timetable is issued at 5:15 to 9. The notification is issued. Then your lordship may see as to the instructions given by the RPSC for these persons. 1535, my lord. 1535 is नंबर 14 में. केंद्र पर प्रश्न पत्र खोलते समय आवश्यक रूप से वीडियोग्राफी करवा लेने हैं, ताकि उसकी तथा उसकी सीडी बनाकर सील लिफाफे में उस समन्वयक को भिजवा देने. It's not that the RPSC was involved in these. There may have been strange incidents of some persons indulging with the local people there. And a few, maybe 1 or 2 centers. RPSC says nobody could have, when the question papers are sent to those centers, they are sent in sealed covers. The manner of opening of these sealed covers is also mentioned. The videography करा के खुलवाएं. Then, my lord, on the same page, because lordship may see कोरोना कोविड-19 के मद्देनजर अति विशेष निर्देश. केंद्र अधीक्षक परीक्षा केंद्र के बाहर भीड़ जमा न होने दें. केंद्र अधीक्षक प्रत्येक केंद्र के प्रवेश द्वार पर अभ्यर्थियों को समुचित दूरी बनाते हुए प्रवेश सुनिश्चित करावें. प्रवेश से पूर्व सभी अभ्यर्थियों के साथ सैनिटाइजर से सैनिटाइज करावें. केंद्र परीक्षा केंद्र पर सभी अभ्यर्थियों के प्रवेश से पूर्व अभ्यर्थियों का तापमान मापा जाना सुनिश्चित कराएं.
Article 6 SBA company justice doing good something with over here. With temporary. How much time would you pitch it?
About 45 minutes.
No, please reduce. 45 minutes maximum. Because we want to conclude as early as
Yes.
possible, but
I try and quickly learn.
lawyers don't allow work on Saturday, otherwise you would have continued. All right, on Monday. Monday will continue at 2. Monday. Monday we will not allow you from the petitioner side more than 1 hour, and we'll ask them to then start. That's all.
For 1 day, accommodation may begin. I'm not sure. He has been out of hospital now. So,
Let's hope for the best.
yes, sir.
I just request
You on behalf of whom?
one of the applicants. So what we extend.
Who is stopping any one of you? We didn't say that you will not.
Item number
Going on always today, auction has not taken place. But if I know clear for tomorrow or for Monday, open my lots and for the matter to be listed because execution proceedings are completed, attachment has been
Grateful.
there, and now auction proceedings are going on. Although it was scheduled for today, my lord, but as per my information which I have received from OIC, auction has not yet been taken.
Why did you not make a mention in the morning? When we take up